Welcome to Namibia at Work, the talk show that explores various aspects of labor and employment. I am your host, Luella Sasele. In today's edition, we break down payment of remuneration, as well as deductions and other acts concerning remuneration. Remuneration is a cornerstone of employee rights and fair work practices, and we are privileged to have Miss Emily Hampolo with us to break it all down. Miss Hampolo, welcome to the program. It is always a pleasure to have experts like you on the show.
Thank you, Mr. Sasele, and thank you for having me today here. Good day to the Namibian workforce as well as to the employers.
Let's start with the basics. Could you walk us through what employers are legally required to do when it comes to remunerating their employees? What does the law say?
Thank you for that question. As provided under Section 11 of the Labor Act, Act number 11 of 2007, I will start off by defining remuneration. Remuneration comes about when the employer and the employee enter into an employment contract. The contract stipulates all the terms and conditions of employment, and one of those conditions is to agree on the remuneration arising from the employment relationship. As you alluded that remuneration is a cornerstone of the employee's right. That is why it comes about when there is an employer-employee relationship. Remuneration is one of the conditions that is very vital.
That's very insightful. Now let's talk about the timing of payment. Could we explain why the law specifies strict timelines for paying employees after they have completed their work hours? And what are these timelines? Why is this significant?
In terms of Section 11, Number 1A, the employer must pay any monetary which the employee is entitled to, not later than 1 hour after completion of ordinary hours of work on the normal pay day, which may be daily, weekly, fortnightly, or monthly. It is significant because a strict timeline ensures employers and employees are aligned with labor laws.
You have mentioned the methods of payment like check, cash, or direct deposit. But what about the procedures when an employee's contract ends before payday? How does the process work, and how is it handled fairly?
Thank you very much once again for that question. Now, when the contract comes to an end before payday, termination of employment should be done fairly and in accordance with the procedures. If the employer follows the procedures as set out by the Labor Act, then the issues of payment will not arise. In terms of Section 11, Number 2, in the case of an employee whose contract of employment is terminated before the payday, the employer must, on the day which the contract is terminated, pay the employee the remuneration to which the employee is entitled to in the manner set out in subsection Number 1B and C as alluded earlier.
Of course, the law also specifies where employees should not receive their payments, like shops or bottle stores, unless that is their workplace. What is the rationale behind this restriction?
Each payment contemplated in subsection 1 and 2 must not be made at a shop, like you have mentioned, a bottle store, or other place where intoxicating liquor is sold or made, or at any place of amusement in that shop. So employers are are restricted from paying their employees in those places unless the employee is employed in that place, but at a reasonable time.
Thank you for that information. Here is something practical for our viewers to understand. Written statement of payment. These are mandatory. Can you share why these are so important and what details they include?
Yes, thank you very much once again. The written statements are mandatory to abide by the law and the provision of the Labor Act. The written statement can be, for example, payslip, in some cases, cash contained in the envelope, and the employee's particulars are contained on those written statements. For example, the employee's name, position, date of engagement, date of payment, rate per hour, ordinary hours worked, overtime, and it also contains all deductions. And lastly, the remuneration that is due to the employee.
Let's touch on remuneration in kind. If someone is paid partly in goods or services instead of cash, what does the law say about ensuring fairness in such arrangements?
Payment in kind should be as narrated once again in the collective agreement, and it should be done as stipulated by Section 11, Number 4 of the Labor Act. If any part of an employee's remuneration is paid in kind, then it must be made in a manner set out in subsection 1A unless the employees request otherwise.
Of course, whenever remuneration is mentioned, the likelihood of having some deductions is always there. Could you tell the viewers as to when and when not an employer is allowed to make deductions from an employee's remuneration?
The deduction is required or permitted in terms of the court order or any law or subject to subsection 2. The deduction is required or permitted under any collective agreement or in terms of any arbitration award or agreed in writing and concerns a payment contemplated in subsection 3. The deductions made in terms of subsection 1b must not, and I repeat that, must not be in aggregate exceed a 1/3 of the employee's remuneration.
Is there limit on deductions, or can the whole salary of an employee just be deducted? And is there any levy due to an employee as a result of those deductions?
Yes, Mr. Sesele, there are limits to how much of an employee's salary can be deducted. An employer cannot deduct the entire salary as stipulated in terms of Section 12, Number 2. And in terms of Section 12, Number 5, an employer must not levy a fine on an employee unless is authorized by the statute or collective agreement.
Any takeaway remarks?
Yes. Lastly, it is only to encourage all Namibian employers to adhere and to commit to paying their employees on the stipulated time in terms of the law and to avoid inconvenience of delaying the employees' payment. This will encourage employees to be motivated and be productive in carrying out their contractual obligation. Lastly, employers are also encouraged to comply to paying their employees the national minimum wage as set out by the wage order as published by the Government Gazette number 218 of 2024. Thank you very much.
Thank you so much, Ms. Ampolo, for shedding light on such a crucial topic. As we can see, clear and fair remuneration practices ensures that both employees and employers can maintain a relationship of trust and professionalism. Should we have questions about today's discussion, kindly drop us a comment or email us at publicrelations.officer@mojlr.gov.na. Let's keep the conversation going. Tune in again next time as we bridge the gap between what workers deserve and what employers can offer, ensuring a fair and sustainable approach to fair labor relations. Until then, I'm Luwela Sasele. I'm signing off. Take care and goodbye.